My lady and my lords.
Mr. Sefton, yes.
May it please you, I appear with Miss Fairley for the appellant. Miss Jordan, Queen's Counsel, appears with Mr. Fieldsend for the respondent.
Thank you, yes. Well, now,
May I ask whether we can take these off or whether we should keep them on, my lord?
yes, you can take them off as far as we are concerned, if you'd be more comfortable. As you've noticed, we've all taken our masks off, which has become a traditional fashion in conducting hearings these days. But there is no requirement to wear a mask, and we certainly do not insist on it. If you are more comfortable without them, and everybody in the courtroom is comfortable with that arrangement, which I sense is the case here, then that is fine.
Most grateful, my lord.
Can I just, before we get cracking,
Yes.
say this? For some reason, and I'm not entirely sure that we've managed to work out why, this case has been listed for a day and a half. Having read the materials, including, of course, the decision, and including, of course, your skeleton arguments, we really cannot see how the case can sensibly take more than a day.
I can explain the listing. That was
Yes.
Lord Justice Lewison.
Yeah.
When he granted permission, he
Yes.
directed it be listed for a day and a half.
Yes. Well, of course, there are a great many authorities in the bundles. How many of them will actually end up by visiting, I'm not entirely sure. But even so, we really do think that we can get through this in a day.
I hope so.
I mean, have you discussed timetable between you?
Not in detail, no, except to say that we will attempt to split the time between us. I will be as quick as I can. There is perhaps more to say than it might look as though there is at first glance. But,
Oh, fine. Well, we'll see how we go. But we distinctly feel that we should be aiming to finish this hearing in a day. There's no pressure, but I'd like you both, please, we all would like you both to focus on that objective.
Understood.
Thank you very much. Yes, Mr. Sefton.
My lords, my lady, this appeal is about statutory fictions. Statutory fictions are often problematic. And the reason they're often problematic is because it's often hard to identify the intended limits of the statutory fiction. Statutory fictions are usually meant to have a limited effect to achieve some limited statutory purpose. But it's often the case that the statute itself does not satisfactorily define the exact limit of the fiction. Now, in this case, Section 91A(d) of the Leasehold Reform Act creates the statutory fiction of an unimproved house, in our case, an unimproved 10 Cheney Walk. And the purpose of that statutory fiction is to identify the discount that the tenant is entitled to receive on the purchase house when she acquires the freehold under the statute. The question is, how far is the fiction of the unimproved house meant to go? We say the fiction of the unimproved house is limited to the physical state of the building. The fictional unimproved house is the same as the actual house, except for the way it is physically laid out. And that's all that the fiction can and should do to achieve what we say is the statutory purpose. Ms Alberti says the fiction is not limited in that way. She says the fictional house on the facts of our case is a house that cannot be lived in as a house without there being a breach of planning control. And the effect of that approach to the statutory fiction is severely to depress the purchase price and to entitle Ms Alberti to acquire the freehold of this house for what we say is vastly less than it is actually worth. And the tribunal below was persuaded of Mr Jordan's submissions. We appeal with Mr Lord Justice Lewison's permission. The way I'd like to structure my submissions, if I may, is to say something about the facts. Now, I appreciate the facts are agreed, but it's important to characterise them the correct way, we say. Then to look at the statute, then to look at the law on deeming provisions, then to look at the statutory purpose and the correct interpretation of the statute. Fifth, to look at the reality principle. Sixth, to look at two analogous decisions that we say are relevant, Railstore and Playdale and Fatal. And finally, if time permits, and taking account of the indications that have been given, to answer a number of short points that Mr Jordan makes in his skeleton.
Yes. One thing you could do on the way through, and I'm sure it will fit somewhere in your scheme, is to tell the court what the law was, the legal position, as to the requirement for planning permission. Can I just say a word about that? from my own familiarity with the planning position, am I right in thinking that at a particular stage in this history, there was a policy in the development plan for the Royal Borough which had the effect of deeming or indicating the local planning authority's position on proposals which would have the effect of reducing the number of residential units, which would not in particular circumstances be regarded as material, as material changes of use. I'm not quite sure what the policy was and what it said. I'm not even sure that I have recalled this history accurately. But of course we must keep in mind the distinction always between what the law is and what policy is. They're not the same thing in planning or in any other sphere.
I'll address it so far as we understand it. As we understand it...
You don't have to do it now.
No.
What we would strongly prefer would be an agreed position on this, because it's not a contentious aspect of the case in the skeleton arguments, nor was it in the
There is an agreed position in the statement of agreed facts, which I'll show you. If it needs to be elaborated
All right,
on, then
fine. Well, we can come to that then.
And see what more detail.
We'll take it in your course, but that is something that we mentioned at the outset because we do want to be clear about it. Thank you.
So to the facts.
Yes.
10 Cheney Walk. It's a Grade 2 listed house in Chelsea. Cheney Walk is a very famous address. Number 10 is a very large house, 7,330 square foot. On the 21st of May 1971, Earl Cadogan, then the freeholder, granted a lease of the building to Gerald Scarfe, the cartoonist. It was a lease for a term of just under 50 years. The term was to expire on the 28th of December 2020. It is common ground that at the time the lease was granted, the house had been subdivided into 5 flats. There was a caretaker's flat in the basement, 4 other flats on the upper stories. And having taken the lease, Mr. Scarfe, in the course of the 1970s, carried out some internal alterations.
Yes. Do we have a drawing that we could look at?
We do. If I can take you first to the statutory declaration that he swore in connection with this claim. It's in the supplemental bundle, and it is tab 2. Begins at page 9, the text is over at page 10. It's quite short. What he says in paragraph 3 is that between 1973 and 77, he made various alterations to convert the property from 5 flats to a single house at his own expense. And he explains in paragraphs 2 and 3 how the original layout is shown on plans A1, 2, 3, 4, 5, and the subsequent layout is B1, 2, 3, 4, 5. So if we look at a sample floor, you go to tab 6, page 33. That's a first floor plan. It's marked historic layout. Most of it's coloured blue, and the blue is the key. It says that the blue is first floor flat 3.
Sadly, I don't have colours.
I'm sorry about that.
Do you have
Help, I
another
can
colour?
hand up my colour version.
I've been favoured with, as has my lord.
I'm feeling very offended.
This is
I think we should remedy this.
satisfactory.
Well, look,
If I can just pass this up for the moment. I would be through.
thank you, Mr. Jordan. Right.
Thank you very much.
So, blue.
So we're looking at the first one, which is page 31.
So if we're on 33, that's the first floor. Blue is coded as first floor flat. The red area is coded as common parts, and as you can imagine, what it represents is the staircase that runs up through the house. And you will see that there are a number of thin orange lines. Those are internal partitions. And what they have done is they've partitioned out what would otherwise have been the floor plan into a number of separate areas. They are marked on the plan. You've got bedroom, kitchen, bathroom, store, and living room.
Yeah, I mean, what was done, and presumably this is, if you like, a traditional way of converting a 19th century house into flats, which has been done countless times in this part of London, to insert partitions that create flats with the minimal intervention.
Yes.
For cost reasons.
Yes, and you install sanitary fixtures and kitchen fixtures.
You put in a bathroom, you put in a kitchen, and you have a flat.
Exactly.
What was once a living room becomes a bedroom, and so forth.
Yes.
And that was done some time ago, and
sometime before 1971, we don't know exactly
we
when.
don't know when. It doesn't matter when, actually.
So if we then go forward to page 38,
Yeah.
that's behind the next tab.
Yeah.
Does my lady have a coloured version of page 38, or in that case, pass one up.
So I'm depleting your bundle.
I'll have some of it left at the end.
Thank you very much.
And what you will see, rather as you would expect, is that the internal partitions have been removed. And there are a number of annotations on the plan saying what has been done. They say removal of kitchen and all associated walls, removal of bathroom and associated walls, removal of locks and swapping of doors, insertion of a new entrance to a formal living room. So essentially, as you would expect, what's happened is that the partitioning has been stripped out, and the surplus kitchen and bathroom fixtures have also been stripped out.
Yeah, so this was taking out stud walls, kitchens and bathrooms.
Yes.
To go back.
Yes, to go back to what you had before.
Yeah.
And it's common ground that there wasn't any planning application or planning petition for those works. That's not because he did them in breach of planning control. It's because, as we understand it, at the time he carried out those works, it was the policy that planning consent was not required for amalgamation schemes involving the loss of fewer than 5 units. And I'll just show you the agreement on that.
Yeah,
it's in the supplemental bundle, page 28. It's behind tab 5.
Yes.
And if you go to paragraph 6, that is what we agreed in relation to RBK's policy prior to August 2014. I don't know if that supplies you with enough detail.
Well, it was really that caused my question, because the policy, I don't think, could have said quite that. That might have been the effect of the policy. The policy couldn't override the law,
no.
But it might have been a clear indication of what the local planning authority's approach would be in the context of material change of use.
I think it's that they didn't regard it as material change of use or material development.
If you could unearth the policy, that
do our best.
I think would help us just to see exactly what it did say. But there's no controversy.
No.
There wasn't a breach of planning control. Nobody's asserted there was a breach of planning control. We don't need to introduce complexities around that. But we would just like to know what the position was with a little more depth than we see in paragraph 6.
We will try and articulate that.
Yeah, thank you. Thank you very much.
So just pausing there on the fact, in the 1970s when all of this was done, it was lawful as a matter of planning control by whatever route one uses. It was lawful for Mr. Scarfe to have the building laid out as 5 flats, and it was equally lawful for him to have it laid out and used as a house. And an owner of the building at this time was free to decide for him or herself what they wanted to use the building for. Now, it's also common ground that the works that were done, that we've just been looking at, were improvements for purposes of Section 91A(d) of the 1967 Act, in the sense that they weren't repairs, they were works that, as a matter of landlord and tenant law, qualify as improvements.
So there's no controversy about that?
No controversy there.
Right.
And from the 1970s onwards, it's agreed that Mr. Scarfe and his wife, Jane Asher, the actress, did use 10 Cheney Walk as a house. We don't know exactly when it started, but they used it as a house throughout the 70s, 80s, 90s, 2000s and 2010s. And then in August 2014, we have the change in planning policy, the event that gives rise to this appeal. Now, at this point in time, the building had been used as a house for 40-odd years. And what happened is that RBKC became concerned about the shortage of housing in the borough. And again, this may not may have articulated it the wrong way, but what we agreed in paragraph 12 of the Statement of Agreed Facts was that as at August 2014, the policy changed so that their policy became one to resist the loss of residential units through amalgamations of existing or new residential units unless the amalgamation resulted in a net loss of one unit only, and the total floor space the new dwelling created would be less than or equal to 170 square metres of GIN.
Yeah, again, for the same reason, we would like to see the policy.
Certainly.
But anyway, there's no controversy about the effect of that.
And the effect of that is that the works that Mr. Scarfe did would have fallen outside the policy.
Yes, because the policy then, as generally in London, I think at the time, and certainly subsequently, was to preserve units of residential accommodation, so far as one reasonably could, other things being equal. It's a very generalised summary of where planning policy was heading at the time and now, actually.
Yes. Yeah. And we agree, and this is paragraph 13 of the Statement of Agreed Facts, that if on the valuation date, which is in 2019, the building was laid out as it had been laid out in 1971, then an application for planning consent to amalgamate it all into a single house would not be successful.
Well, it's quite stark. It says would have had no chance of success.
Yes.
And
as you can imagine, at one point we might have hoped to persuade someone that there was a chance of success, but it is agreed that no, there was.
yeah, I mean that includes.
It is stark.
That includes on appeal, presumably. That statement, yeah, because an inspector would have been expected certainly to uphold the local planning authority's refusal of planning permission.
Yes.
Very clear.
Now, that was the change in planning policy, but again, just pausing there, as at August 2014.
Yeah.
How did that change in planning policy affect Cadogan, and how did it affect Mr. Scarfe? Now, if one puts aside the Leasehold Reform Act 1967 and what is said by Mr. Jordan to be the effect of the deeming provision, then this change in planning policy had no effect on either Mr. Scarfe or on Cadogan, because it only affected other buildings. It didn't affect this building. It didn't affect Mr. Scarfe because at the point in time when the policy changed, the building was laid out as a house and had been used as a house for many, many decades. And so the continued use of the building as a house could not represent a change in use or a development for the purposes of planning.
Well, and that was because it was now immune from enforcement.
Yes.
Yes. By virtue of the lapse of time. The relevant lapse of time would have been, I think, 4 years.
Yes.
Is that correct?
I believe so.
Yeah. I mean that. Please don't take that as, you know.
But it's only 4 years
so,
now,
but,
I think.
But I think, yeah, that at the time it would have been 4 years in residential use or use as a dwelling house. I think I'm right in saying. But again, if there's any dispute about this, we ought to know. It probably doesn't bear at all on the issue
Probably
here.
doesn't matter because the use as a single house has been going on for 40 years.
It was in law an established use. In other words, a use that could not be enforced against successfully.
Exactly.
Yeah.
And just as it didn't affect Mr. Scarfe, it didn't affect Cadogan either, because what Cadogan had in 2014 was a reversion to a lease of the building that was going to come to an end in about 6 years' time. And in 6 years' time, what Cadogan would get back is a building that it was lawful to use as a house. And to echo a phrase that we'll come to in a couple of the authorities later, the change in planning policy had no existence as between Cadogan and Mr. Scarfe. But what I mean by that, that's a phrase that's used in Basingstoke and Dean and Railstore and Playdale. What I mean by it is that it only affected other people. It didn't affect them. The next and last relevant fact is the service of the notice of claim on the 14th of May 2019. But by that point, the lease had very little time left to run.
Yeah.
It It was going to expire in a year and a half. And on the 14th of May, Mr Scarfe served notice of claim to acquire the freehold under the Leasehold Reform Act 1967. I mean, as a fact, he did that not to acquire the freehold for himself, but in order to be able to sell the benefit of the rights the notice created to Ms Alberti, which he did very shortly afterwards. And again, as a fact, not that it really matters, but Ms Alberti intends to comprehensively refurbish the house and to live in it with her family. And again, just as with 2014, just before we leave the facts, I'd like you to pause and ask, on the 14th of May 2019, again, if you put aside the Leasehold Reform Act, what is it that Cadogan owned at that point in time? We had a reversion that was going to fall into possession in about a year and a half. There would be a slight complication, actually, when it ended, because the 1989 Act would continue the tenancy temporarily. But it would only be temporary because the 89 Act rights give tenants the right to call for an assured tenancy. And because of the value of this house, the tenancy they'd have called for would have ended up not being an assured tenancy, so it would have been terminable. So what would have happened in practice is the tenancy wouldn't have stopped dead, but after a period of hiatus, Cadogan would have been able to recover possession. And what Cadogan would then have had is vacant possession of a 7,000-odd square foot house in Chelsea on Cheney Walk, which it's lawful to use as a house, which we say is worth something in the order of £11 million. Can I turn now to the statute?
Yeah.
The Leasehold Reform Act 1967 is a compulsory purchase statute, not in the sense that it gives the state the power to acquire land from private individuals, but it gives the state giving private individuals the power to acquire land from other private individuals. And as with any compulsory purchase statute, the freeholder whose interest is being acquired is entitled to be paid compensation. And in a few cases, now quite rare, the compensation is calculated under Section 9(1). But in most cases, and in our case, it's calculated under Section 9(1)(a). And you'll find that in the authorities bundle, tab 1A, over on the second page behind the tab, page 49 at the bottom. And what it says is that notwithstanding the foregoing subsection, that's notwithstanding Section 9, subsection 1, the price payable for a house and premises, the rateable value of which is above the specified limits, shall be the amount which at the relevant time the house and premises, if sold in the open market by a willing seller, might be expected to realise on the following assumptions. A, on the assumption that the vendor was selling for an estate in fee simple subject to the tenancy, but on the assumption that this part of this Act conferred no right to acquire the freehold or an extended lease. So what we are told to envisage is that there is a hypothetical sale. The sale is of the freehold subject to the tenancy. So it's of Cadogan's freehold interest subject to the 1.5-year unexpired term of the lease. And it's a sale taking place in the open market. And what that phrase signifies is that the sale is taking place in the real world and subject to the effect of any counterfactual assumptions you're required to make. Whatever value the interest has in the real world is meant to be reflected in the valuation. And so, as it is often said about these sorts of formulae, although the sale is hypothetical, there is nothing hypothetical about the world in which that sale is taking place. Subparagraph A there contains two assumptions, one factual and one counterfactual. The factual assumption is that the sale is of the freehold subject to the tenancy. That reflects reality, that is the interest that Cadogan has and that the tenant is acquiring. The second assumption is counterfactual. It's an assumption that this part of this Act conferred no right to acquire the freehold or an extended lease. And that counterfactual assumption is to protect or benefit the landlord, because the existence of the statutory rights under the Act has the potential to depress the value of the freehold interest, and therefore this assumption counteracts any possible depression of the freehold interest as a result of the existence of the statutory rights. It's sort of the equivalent of the no scheme assumption in compulsory purchase cases.
Yeah, equivalent to the no scheme.
And so, so far, all of this is about getting to the real world value of what Cadogan owns on the valuation date and that is being compulsorily acquired by the tenant. Now we then come to assumption D, which is what gives rise to the issue. And that's the assumption that the price be diminished by the extent to which the value of the house and premises has been increased by any improvement carried out by the tenant or his predecessors in title at their own expense. So it's a slightly circuitous provision. It doesn't actually direct you to go straight to an unimproved house. What it does is it says, well, look, in the real world on the valuation date, the value of the house would be X. But by how much was that value of X increased by the improvements carried out by the tenant? The answer to that is Y. You then deduct Y from X in order to identify the amount of the statutory compensation. Now, in order to work out the amount that you have to deduct in order to give effect to this assumption, you have to hypothesize two sales. But first you have to hypothesize the sale of the house and premises as they actually exist on the valuation date. How much would that fetch? And then second, you have to hypothesize the sale of the house and premises on the same date, but without the improvements. How much would that have fetched? And can I just dip briefly into Shelson? We need to come back to Shelson later, but just very quickly, one goes to tab 28.
Yes, we're coming back to the Act, obviously. Are we?
Sorry?
We're coming back to the Act.
We'll come back to the Act. I just want to very quickly...
Keep that open then.
Tab 28, and if you were to go please to page 814 at the top, it's page 470 at the bottom, to paragraph 40. It's in the opinion of Lord Millett, where he says that the Lands Tribunal compared the property at the valuation date with the property as it was when originally let, but there is no warrant for this approach in the wording of the subsection. The extent to which the value of the house and premises has been increased by an improvement is simply the difference between the value of the property with the improvement in question and the value of the property without it. And that is where the issue arises. The first value, the value of the property with the improvement, that is the real house in its real condition being hypothetically sold in the real world. The second value, the value of the property without the improvement, that's where we disagree. What is the property without the improvement? And our case, as I outlined at the start, is that the property without the improvement is exactly the same as the property in the real world, except that you notionally remove the physical improvements. And that's all you do. But what you do not do is to write a new and different history for the house.
I mean, that is the crux of the case, isn't it?
It is.
What is it that you regard as the property without the improvement?
Exactly. And obviously I'll come on to explain why we say the property without the improvements is as we say it is. But just before we get to that, can I just make one point, which is that the valuation exercise that we say that therefore requires is not a complicated. It's not conceptually complicated, it's not practically difficult. What you do is you say, well, look, here's the house as it exists in reality. What would somebody pay for it? And then you ask yourself, well, let's assume that the partitions have gone back in and the old kitchen and bathroom fixtures have gone back in. How much less would somebody then pay for the house? It's not as a valuation exercise, that's not difficult. And the answer will usually be that the purchaser will estimate the time and cost involved in taking those partitions back out, removing the fixtures and so on, and that will result in the diminution in value, the reduction in their bid. I simply make this point that it's not a complicated or abstruse exercise.
No.
Now, what Mr. Jordan says is he says, well, you do a lot more than that. He says you don't just assume that the improvements have been removed on the valuation date. He says what you do is you assume they were not carried out at the time when they were carried out in fact. So what he says is, well, we need to rewind the clock to the 1970s. We have to hypothesize that in the 1970s, Mr. Scarfe did not take out any of the partitions. He didn't take out any of the kitchen and bathroom fittings. And he says, well, if the partitioning and the kitchen and bathroom fittings had not been stripped out, then Mr. Scarfe would have used the building as 5 flats, not as a house. I don't know why he says that, but presumably the idea is that Mr. Scarfe would have held the lease as a rental investment. Or maybe Mr. Scarfe would have lived in one of the house flats and rented out the other 4. I don't know. But what he says is you have to assume that the building was used as flats, 5 flats, throughout the 70s, the 80s, the 90s, 2000s, the 2010s, so that, and this is the key to it, when you get to 2014, when the planning policy changes, he says on that date, you have to assume counterfactually that the building was being used as 5 flats and not as a house. And therefore, the use as a house is not an established use at the point when the change in planning policy occurs. And as a result, when you get to 2019, you're caught by the new post-2014 policy, which says that if you're amalgamating more than 2 flats or ending up with more than 170 square metres of floor space, you won't get consent for your works. Now, the statutory language of Section 9(1)(a)(d) doesn't tell you what the answer to this question is. When I wrote my skeleton, I said it did, but I think I was being rather too optimistic.
Oh, so wait a minute. Well, if you're changing your skeleton, we need to know where you're changing.
Well,
I
put
sorry,
all I mean
nothing. Don't take anything more from that observation than that we want to be absolutely clear what you want to say to us.
I just mean I put my case very hard in the skeleton. It's in paragraph 21.
Yeah, let's just turn that up. 21, yes. And what do you want to say instead of what you have?
Well, to be honest, everything I say in section 21 is actually fine. It's more section 20, subsection 1, where I said the respondent's approach is wrong because it departs from the statutory language.
Okay, so paragraph 20.
Subsection 1. Subparagraph 20.
Yeah, so you've got those 4 propositions in 20 years. And what do you want to change?
The first proposition, just strike a line through it.
Oh, you don't want that?
No, because I think that's putting it too high. Because actually, when you look at the language of the statute, what it does is it tells you you've got to hypothesise a sale of an unimproved house. It doesn't actually tell you what that involves.
It doesn't tell you the ingredients.
It doesn't tell you the ingredients, precisely.
Right.
Which is why, for my part, I was concerned, not convinced, something by 21.
Yeah, well, and you were right not to. I'm putting it far too high.
Okay, well that's clear enough. Thank you.
Now, again, just pausing before we move on, I want to identify the consequences.
Consequences?
Yes.
Yeah.
Because the consequences of our respective approaches are extreme. Now, our case is that in the real world, on the valuation date, the freehold interest in a large house in this famous location would have fetched £11.15 million. That's not especially surprising. That may be at the top end, but that's not especially surprising for what we're talking about here. And that is what we say our interest was actually worth in the real world on the valuation day. And if you ask yourself by how much would the value of that house have been reduced if you were to assume the partitions are put back, kitchen and bathroom fixtures are put back, and so on, the answer is probably not very much, if at all. It wouldn't cost a purchaser very much in the scheme of things to do the works now that Mr. Scarfe did in the 1970s. And so the value difference is likely to be small.
Yeah, to do those works, to get back to a single dwelling house with all the value attached to that, I mean, one might almost say that it's obviously attractive proposition to do if one's going to realise that value. That's not the question here. I mean, the question here is whether or not, as I see it provisionally at least, as this question, whether or not when you make the assumption that's required by the statute, you inevitably have to take with the improvements the necessary consequences of those improvements in terms of lawful use, or not. Is that a fair? I mean,
that's fair. I would quibble perhaps with the word necessary.
Well, yes, it's not. I haven't sought
that,
to formulate it precisely, but I mean, what divides the parties is that you say this is very simple. You only look at the physical improvements. Yes. You do not rewrite the history and the planning history.
No.
You leave alone that which has become established, consequent upon the improvements. And there's no dispute, I think, that it was consequent and only consequent upon the improvements that the established use came to be as single dwelling house.
Yes.
That's not in dispute at that point.
No.
In other words, you couldn't have got to where you got to without doing the improvements.
You could physically have lived in the building as a house. It had bathrooms, it had kitchens, it had living facilities. You could have, but we have agreed that the effect of the works was to enable the building to be used as a house. You wouldn't in practice occupy 5 flats as if...
When you're looking at your,
yes.
as you're so keen on looking at realities,
yes.
it seems highly unlikely that Mr
Sure.
Scarfe and Ms Asher would be
I
living
agree.
in an unconverted 5-flat
Yes.
property in Cheney Walk for 40 years.
We take that on the chin. Yes.
Yeah. So that's really, that is the dividing issue.
And I promise I am coming to why we say we're right about this. I just wanted briefly to identify where you end up with on the figures, because
I mean it's a stark disparity in value.
And the reason it's so stark is because.
Sorry, were you going to tell us what the other value is? You've
Well,
told us what the top value is.
So the other value is that Cadogan hasn't committed itself to 1 year, but Mr. Jordan has. It's 2.5 million.
That's not agreed, though.
That's not agreed. So the 11.5 million and the 2.5 million, they're the bookends. That's Miss Jordan's best case and mine.
Yes, there's an intermediate value though, which is 4.
Well, that is yes and no. That is what Mr. Jordan says the freehold would sell for if it was lawful to use it as a house. That, he says, is the equivalent of my 11 million. But actually it's not, because when you look at his statement of case, that 4.5 million is predicated on a number of other, we say, peculiar assumptions. So
do we need to get into that?
We don't.
No. I wondered about that. I was intrigued actually to work out how you could get that differential between 2.5 and 4.5, whatever that second figure was. But we don't need to go there.
You don't need to go there, but I can tell you basically how how you end up with the 2.5.
Yeah.
And that is important. The way you end up with the 2.5 is that you say on Mr. Jordan's case, look, this property won't sell into an owner-occupier market of people wanting to buy themselves a house to live in, because they can't use it as a house. The only market it will sell into is the market consisting of small developers looking for a small development project. And so the buyer will be a developer, he says. And the developer will obviously carry out a residual valuation to work out what he's prepared to pay. In other words, what he'll do is he'll say, right, I'm going to come in, I'm going to refurbish these 5 flats. Once I've refurbished them, I'll be able to sell them for A, B, C, D, E. And it's going to cost me X million pounds to do the work. The finance cost will be X, whatever. Deduct all of that from my gross development value and leave me with a residual figure, which is the amount I can afford to pay as a developer to carry out this project and make the profit I want to make and exit the scheme.
Yeah.
And that's what whittles the value right down to the 2.5.
Right, so that would be coming in, doing the necessary works.
Smarten up.
I mean, given the market that one's looking at, which is a matter of common knowledge, I imagine, high-end prime, Chelsea, Riverbank location, you know, the finish is going to reflect that market, isn't it? I mean, that's all common sense, isn't it?
Yes, and of course one of the things that sucks value out of that approach is that you lose quite a lot of the floor space of the house because you have to have common parts. You're using it as a block of flats, and the common parts become essentially valueless. Whereas if you're selling the building as a house, purchasers will attach value to those parts of the building.
Yeah. So the market is a developer's market. That's really what you're saying. And that dictates the value of 2.5.
Exactly.
Right, well, anyway, that's in a sense a bywater, if I can use that expression, of the mainstream.
Now, I said I would next turn to the law of deeming provisions, law of statutory fictions. Could I ask you to take up tab 12 in the authorities bundle, a case called DCC and Revenue and Customs, decision of the Supreme Court in 2011.
Sorry, the tab number again?
Tab 12.
Sorry.
It's a tax case. It involves what are called repo transactions, which I understand to be transactions where you sell a financial instrument on terms that you are committed to buying it back on a future date as a means of effectively providing secured loan finance. Beyond that explanation of the facts, I'm afraid that the facts of this case are far above my pay grade. I try as I have to understand exactly what the issue is. I wouldn't dare to try to explain it. But I don't need to, thankfully, because the passage I want to look at is on internal page 57. So page 57 at the top, page 144 at the bottom. It's paragraph 36, beginning under the heading Statutory Hypotheses. And you see in 36, Lord Walker says that as DCC's printed case notes, Parliament's now swept away the statutory provisions with which the court is concerned in this appeal. There's a new code. DCC's printed case suggests that one of the reasons for the new code was to get away from the almost inevitable problems arising from statutory fictions. It is in fact the problems raised by statutory fictions that give this appeal such general importance as it has. And there's then a reference in 37 to IRC and Metrolands and to the judgment of Mr. Justice Norse. That's at the bottom of the page. He says, when considering the extent to which a deeming provision should be applied, the court is entitled and bound to ascertain for what purposes and between what persons the statutory fiction is to be resorted to. It will not always be clear what those purposes are. If the application of the provision would lead to an unjust, anomalous or absurd result, then unless its application would clearly be within the purposes of the fiction, it should not be applied. If, on the other hand, its application would not lead to any such result, then unless that would clearly be outside the purpose of the fiction, it should be applied. So one has to look for the identify the purpose of the fiction. And actually in this case, as we'll see, the purposes have been clearly stated for us by the House of Lords. And then we have to look at the results of applying the statutory fiction in the two different ways for which we respectively contend, and identify the results and characterise those results. Are they absurd, anomalous, unjust? Or do they clearly meet the purposes of the statutory fiction? That's the basic job. And if one goes over the page, there's a citation, paragraph 38, of a judgment of Mr. Justice Peter Gibson. If I could just ask you to read that to yourself, please.
Yes, thank you, yes. Well, that's what you've just said.
It's much the same as the previous passage. But then, paragraph 39, citation of judgment of Mr. Justice Newberg and Jenkinson Dickinson. Can I ask you to read that to yourself as well, please? it's saying to some, I don't want to gloss it too much, but it's saying you've got a, when you're dealing with a statutory fiction, a deeming provision like this, you've got a, as it were, a little bit more elbow room than you might otherwise have, just
because you're in the terrain of artificial assumptions.
Exactly, where it's not always realistic to expect every consequence to have been thought through. Paragraph 40, before we move on.
There's a telling dictum of, it's quoted actually by the Tribunal, about minds boggling.
Yes, that's from the East End Dwellings case.
East End
Lord,
Dwellings, yes.
Lord Asquith.
Yeah. Lord Asquith. Are we coming in that direction?
Well, yes. Well, can I just say this about that? That's a quotation that tends typically to be wheeled out when someone wants to say, well, you're told to assume one unreal thing, therefore let's work out all the other things that would also be unreal if the first thing is unreal. That's what it tends to be used in support of, because that's what it sounds like it's saying.
Yeah.
Actually, on the facts of East End, that's not what Lord Asquith was really saying at all.
All right, well, I've created a distraction, forgive me for that, but it was a telling dictum which perhaps you're going to come to deal with at some point.
Just before we leave DCC, can I just ask you to read paragraph 40 to yourself,
40,
where Lord Walker tries to give a more concrete example of what he's talking about. Yes.
Nice example.
Exactly. It tells you that although it is necessarily a consequence of the mother's statement that either she was born a generation earlier or they're both the same age, neither of those things was the point of her hypothesis. So you don't go there, even though it would. That's why I quibbled with your word necessary.
Well, it also assumes that the 40-something woman is a 40-something woman in the contemporary age, not in some previous age, because otherwise she wouldn't have lived through the miners' strike.
Yes.
So there's another assumption inherent in that one.
Yes.
I mean, yes, but one sees the purpose of that example.
Yes.
It's to illustrate the points that have really been
Quite.
Taken in the previous three paragraphs. Yes. Is that right?
Yes.
Yeah.
My lords, the other case on deeming provisions is tab 16. It's Fowler, the Revenue and Customs. This is also a tax case, but it's a tax case that I was able to understand. And the facts very briefly, that Mr. Fowler was a taxpayer resident in South Africa. He worked as a diver in the UK continental shelf sector of the North Sea, and so he fell within a UK-South Africa double taxation convention, referred to in the judgment as the treaty. Under Article 14 of the treaty, employees are taxed in the place where the remuneration is earned, so that's the UK. And under Article 7 of the treaty, self-employed persons are taxed where they are resident, so that would be South Africa. So the question was Mr. Fowler employed or self-employed? Because that would determine where he was to be taxed. He was employed, he was taxed in the UK, self-employed taxed in South Africa. And the treaty did not define employment, but it did provide, you go to paragraph 8, it did provide in Article 3.2 that as regards the application of the provisions of this convention at any time by a contracting state, any term not defined therein shall, unless the context otherwise requires, have the meaning that it has at that time under the law of that state for the purposes of the taxes which this convention defines. And the relevant UK tax legislation was the Income Tax, Earnings and Pensions Act of 2003. And Section 15 of that Act created a statutory fiction. And the statutory fiction is in paragraph 23, which quotes the whole of Section 15. That section applies to persons employed as divers in the UK or in an area designated by order in council under Section 17 of the Continental Shelf Act. And then subsection 2, the performance of the duties of employment is treated for income tax purposes as the carrying on of a trade in the United Kingdom. So the taxpayer was, well, look, suppose I'm in employment, Section 15 of this Act deems me to be self-employed, and therefore I pay tax in my country of residence, which is South Africa. That was his case. Paragraph 27 contains a summary by Lord Briggs of the law as it relates to deeming provisions, first the DCC. I'll just ask you to read that to yourself. It contains the statement of Lord Asquith.
Yes. Now this is the passage, I think, which is referred to by the Tribunal.
Yes, it is.
And contains, yes, as you say, the dictum of Lord Asquith.
Yes.
In East End dwellings, Finsbury Borough Council.
And if one then goes to paragraph 28 and over the page to the citation from the judgment of the Court of Appeal for Justice Henderson, I'll ask you to read to yourself the quotation from A to C on page 2237. And the Supreme Court overruled that judgment, and we see, for present purposes, the reason why in paragraph 33 on the final page of the judgment.
Yes.
Section 15 creates this fiction not for the purpose of deciding whether qualified employed drivers are to be taxed in the UK upon their employment income, but instead for the purpose of adjusting how that income is to be taxed, specifically by allowing a more generous regime for the deduction of expenses. And so that's an example of a case where the statutory fiction, taken literally, would have caused the taxpayer to be treated as self-employed. But the Supreme Court reasoned from the purpose of the statutory fiction, say that statutory fiction wasn't meant to bite on this particular factual situation.
Yes. Thank you.
And so the critical job that we need to do is to identify, obviously, the purpose of the statutory fiction here, and then to see whether the results of our competing approaches are within or without the purposes of that statutory fiction. And although the statutory fiction is often unclear, we are blessed, in this case, with three statements of what the purpose of the statutory fiction is, all of them at House of Lords level in Chalson. So if we can go back to Chalson, it's tab 28.
Just a second. Yes.
Just before I show you the passages, can I just put the judgments into context?
Yeah.
It's important to understand what the issue was in Chalson, because the issue in Chalson is very much not the issue in the present case. The issue in Chalson was not about the availability or otherwise of planning consent for improvements that were being disregarded. The question was, are there any improvements to disregard? That was the question in Chalson. Chalson concerned a house on Hamilton Terrace in St John's Wood. It had been let on a series of leases, the most recent of which was granted in 1947. So sometime after, in 1947, the house was laid out as a house. Sometime after that, we don't know exactly when, it was divided up into 5 flats. And then later on in the 1990s, it was converted back into a house. And after it had been converted back into a house, the claim for the freehold was brought under the 67 Act. And the question was, had the house been improved? And what the landlord said, he said, well, it was a house on the valuation date, laid out as a house on the valuation date, and it was laid out as a house at the start of the lease, so it hasn't been improved. You simply compare the state today, the state at the start of the lease, and there was no difference. The tenant said, no, you don't. What you do is you simply identify some works that are improvements, and then you rewind to, you ask yourself, what would the state of the building have been if those improvements had not been done? He said, well, the works I carried out to convert the 5 flats into a house were improvements, so you must value it as 5 flats. That was the argument. And the tenant's case was accepted, the landlord's case was rejected. But I stress that there were no planning control issues in Chelsea. It was nobody's case that if you value this building laid out as 5 flats, you're then caught by a planning policy that prevents you from turning it into a house. And the value differential, it's almost surprising it got to the House of Lords, because the value differential was £398,200 if it's laid out as a house, £275,298 if it's laid out as flats. Value differential just represented the cost of doing the works. Now, the three statements of the purpose of the provision. The first we find in Lord Bingham's opinion. That's internal page 805, page 461 at the bottom. And if we just start at paragraph 2, it says, the Leasehold Reform Act 1967, as amended, gives to a qualifying tenant a statutory right to buy the freehold of the house of which he is the leaseholder. The effect is that the owner, instead of recovering his property on the expiry of the lease in the ordinary way, receives a capital sum representing the value of the house at the date when the tenant gave notice of his wish to buy. Calculation of that value is governed by a statutory formula clearly intended to yield a fair result as between tenant and owner, conferring no undue benefit on either. Now, I stress that because Mr. Jordan said below, and I expect he'll say again, that all of the components of the statutory formula are tenant-friendly. They're all designed to give tenants the freehold at the cheapest price possible. And that is not Lord Bingham's understanding of how the statutory formula is meant to work. It's not meant to confer an undue benefit on either side. And he then, in paragraph 3, approaches section 9.1a(d). He says, a further assumption with which alone this appeal is concerned is section 9.1a(d). He then quotes the text of that assumption. He says, this statutory language makes plain that the price will be diminished under this head if and only if it's found that 1, works of improvement, meaning works other than renewals and repairs, have been carried out by the tenant or his predecessors. 2, that the tenant or his predecessors have carried out these works at their own expense. And 3, that these works have increased the value of the house. To the extent of the increase attributable to those works, the price payable for the house is diminished. The fairness of this provision is obvious. It would not be fair if the tenant were obliged to pay an enhanced price to the extent that such enhancement was attributable to works done by him or his predecessors in title, probably voluntarily, at their own expense. The tenant would, in effect, be paying twice. It would not be fair if the owner received a price inflated as a result of works done by the tenant or his predecessor in title, probably voluntarily, at their own expense. The owner would be reaping an adventitious gain as a result of works which he had had no right to require. So that's Lord Bingham. He thinks the fairness of the provision is obvious, and it's about not requiring the tenant to pay twice. Lord Hoffman also addresses the statutory purpose at page 809, and paragraph 21. Part 4 lines into paragraph 21. He says, in considering whether an improvement has added value to the value of the house, the comparison is simply with the house as it would otherwise have been. This seems to me fair to both parties. If the tenant had not carried out the reconversion, the landlord's interest would have been the reversion on a house converted into 5 flats. The tenant was under no obligation to reinstate. If the tenant increases the value of the landlord's interest by expenditure on reconversion, it would not seem fair that he should have to pay a second time when the landlord's interest is valued for the purposes of a sale of the freehold. So he emphasises the same thing that Lord Bingham emphasised, which is avoiding making the tenant pay twice. And then finally we have Lord Millett at page 812. In paragraph 31 he sets out the 3 conditions for the assumption to apply. And then he says in 32, such a condition would frustrate the purpose of the subsection. It is designed to avoid the tenant having to pay a price which reflects a value in the property for which he has already paid. If the tenant carries out alterations to the property which enhance its value, he thereby increases the value of the landlord's reversionary interest which he afterwards claims to acquire. The subsection prevents his own expenditure, resulting in an increase in the price he has to pay. So, in all three opinions, there's no indication that the statutory purpose is obscure or difficult to fathom. Its purpose is basic fairness as between the landlord and the tenant. And they all indicate that it's to avoid the tenant having to pay twice for his improvements. Because if he's made to pay twice, that wouldn't be fair.
Just exploring that a moment, if you go back to Lord Bingham, one element of what he says in paragraph 3 is that the owner would be reaping an advantageous gain as a result of works which he had no right to require. Might that be said to apply?
That is clearly Miss Jordan's case. Yes. There is a tension.
Yes.
But we say that the basic statutory purpose is really quite easy to see. It's easy to see if you just think about some simpler facts. If a tenant pays £25,000 to install a smart new kitchen in a house, and then having done that brings a claim for the freehold, it would not be fair for the freeholder to be able to say to the tenant, well, the price you're going to have to pay me for the freehold is £25,000 more than it would have been otherwise, because look, what you're getting is the freehold of the house with a smart new kitchen in it. That would be obviously unfair, because the tenant would be having to pay twice for the kitchen. He pays once to put it in, and then he would have to pay a second time through an increased price for the freehold. That is the obvious unfairness that the statutory fiction is seeking to avoid. And it addresses that by reference to value rather than price, because it needs to do that in order to be correspondingly fair to the landlord. Because it is frequently the case that improvements add value that declines over time. The smart £25,000 kitchen might add £25,000 to the value of the house when it is installed, but over the years it ceases to be a smart new kitchen, it becomes a tired old kitchen, and the value that it adds declines. And so it's obviously unfair to a landlord to adjust the price by reference to the tenant's expenditure directly. It has to be tempered by regard to the value that it is added. And it's that way, we say, that the statute attempts to yield the fair result as between landlord, tenant and owner, conferring no undue benefit on either, that Lord Bingham.
But if equally you convert your attic into living accommodation at a cost of £100,000 and the value of the house rises by £150,000, then you take off the whole £150,000.
You do. And the value can be greater than the expenditure, no question. Although the value will tend to be related to the expenditure, in the sense that if I'm thinking of bidding for a house, two identical houses, one with your loft conversion and one without your loft conversion, the difference between what I will pay for one and the other is unlikely to be vastly different to the cost of carrying out the works and the time it will take me to do it. But so I accept that the value difference can be greater than the price, but there's always going to be a relationship between them. And what is wrong about Mr. Jordan's case, and what generates such a striking result here, is that the value is completely untethered.
Sorry, the value is completely
untethered from
the
extent of the physical works and the cost that they would have involved and would involve today. Now, I just want to make 6 overlapping observations as to why we say Mr. Jordan's interpretation is outside the scope of the statutory fiction.
Right. Are we putting Charleston away now?
Yes, sorry.
We are.
Yes.
Okay, so we can do that. And your 6 propositions,
My 6 propositions.
are they foreshadowed in your skeleton argument?
Yes, I think so. They're perhaps not as well ordered as I'm now
Well, no,
attempting to
No, that
be.
doesn't matter. But if you are on the way through, if you were able to identify, roughly at least, how they correspond to your skeleton argument, that will assist us. Yeah.
I'll do my best.
Thank you.
The first point, this is standing right back from the detail, is that when you look at the bare end result of Mr. Jordan's approach, what it does is to generate an enormous windfall for the tenant.
Sorry, did you say a lawless?
Sorry, an enormous.
Is it a
sorry.
lawless windfall? I was thinking,
Well, we say it is lawless.
I was putting it a bit
but
high.
besides that, it's enormous. It's an enormous windfall for the tenant. Whoever's figures you take,
Thank you.
it's enormous. Because what Ms Alberti is getting is the freehold of a building she can use as a house, and on his case what she is paying for is the value of a freehold that you can't use as a house. She gets a windfall. And we say it's entirely anomalous for her to have to pay for one thing in order to get something entirely different. And can I just ask you to, as it were, imagine yourself into Ms Alberti's position, and assume at the end of this case that you are persuaded by Mr Jordan's submissions, with the result that his application of the hypothesis is correct, and you're going to get the house for £2.5 million. How are you going to feel about that? Are you going to feel relief that you've managed to fend off the Cadogan estate's unjust attempt to force you to pay an unfairly high price? You're not. You're going to feel like all your Christmases have come at once, because you will be delighted and surprised to discover that the statute has worked in such a mysterious way that it's allowing you to acquire the freehold of an £11 million house for £2.5 million. You'll be surprised at somehow the combination of some minor works done 40 or 50 years ago with a change in planning policy in 2014 that doesn't affect you, it doesn't affect Cadogan, has somehow combined with the statute to generate for you a very, very large discount on the purchase price. Now, maybe a slightly glib observation, but what I'm trying to articulate is that intuitively, the end result feels as though it is outside any legitimate purpose that one can discern in the statutory assumption. To go back to Lord Bingham's phrase, if the statutory formula is meant to confer no undue benefit on either side, I say if Mr Jordan's right, it does confer an undue benefit on Ms Alberti. The second point is a point I mentioned already, which is that...
Sorry, just before you... Sorry to interrupt you, but is it possible now to indicate roughly where those points might be gathered? I don't know, perhaps your junior...
Perhaps my junior...
I don't want to burden her with unwelcome tasks, but it really would help us. Not necessarily straight away, of course.
We will provide.
Yeah, that's very kind of you. Thank you both. Yes, second.
Second point is that what is happening here, this is the point I mentioned already, is that the tenant is getting a discount that's out of all proportion to the expenditure which was sent to generate that discount. It is clear from the statute that it is the fact that you incur expense on the improvements that entitles you to the discount. Section 91AD is clear about that. It's not any old improvements that trigger the right to the discount. They've got to be improvements carried out by the tenant at its own expense or the expense of its predecessor. And we see that from the statements in Chalson. It's the fact that you have paid for the improvements that means you shouldn't have to pay for them a second time. And
well, this is close to your first point, isn't it?
yes, well, I said they are overlapping points. There's a great deal of common themes.
So it's point one. I don't want to paraphrase unduly, but point one is windfall. Point two is enormous windfall.
I mean, it might unkindly be said that if you're right, Cadogan gets a windfall because it didn't do anything to bring about the use as a house.
Sure.
And it's the use as a house
Yes.
that produces the much greater value. If nothing had happened at all, well, you'd get what Mr. Jordan says you
But
get.
it's where do you cut the circle? And where you cut the circle, we'll go on to the principle of equivalence and the reality. Where you cut the circles, you ask, well, putting the statute to one side, what does Cadogan have? And what is it that's being taken away from us? And that's the starting point, we say. There is another point too, so related to that, which is that I was trying to think about this. I set my alarm clock for 7 in the morning. I get up, and on my way to work, I'm crossing the road, and I'm knocked down by a car that has jumped a red light. Now, I'm injured. What has caused my injuries? It's the car jumping the red light. That causes my injuries. I wouldn't have been injured if I'd set my alarm clock for 7:05 or 6:55, but nobody would say that setting my alarm clock was the cause of my being injured. And the works that were done here are not the cause of the discount. So I'll come on, this is another of my 6 points, but it's not actually the works that are the cause of the discount. It's the change in planning policy.
The change of?
The change in planning policy, which they did not cause. But sorry, that is a point I'm about to come on to. But sorry, just to return to the second of my 6 points. Yes, it's enormous discount, but more specifically, it's lack of proportion between what you spend and what you get as a discount. The two end up, on Mr. Jordan's case, being entirely untethered.
I mean, neither of these is in itself a legal point, unless you tie it to a principle such as fair compensation, or something,
but also tied to the statements in DCC about how you approach a deeming provision. You say, well, what's its purpose? And we see that in Chelsea.
Yeah.
And then, are the results that it generates on Ms. Jordan's approach, are they anomalous? Are they producing results that are clearly inside that statutory purpose, or do they look to fall outside?
This goes to the credibility of the purpose as construed by the other side.
Yes.
Is really the point.
Yes.
I mean, that's the focus.
Does this come under your heading reality then?
I suppose so. So
Yeah, no.
was actually going to,
just we've done statutory purpose.
well, no, we're
going
not
back
actually
to a
on to
little
reality.
list.
The reality principle is something slightly different. But so no, I'm afraid we're just finishing off on statutory.
So this
This is
isn't you warming up for reality. This is still in statutory purpose. Thank you.
Right. So fine. So
All right, we're on them.
we're now coming to 3.
So point 3, this is the point I just touched on with my Lord Justice Newey, is that the thing that generates the discount here is not actually the expenditure, and it's not the physical works, it's the change in planning policy in 2014. And I say that because if you rewind to the 1970s, just before Mr. Scarfe did the works, when the works were done, they may well have increased the value of the house, but that increase in value would have been by reference to the cost of the works and the time it would take to carry them out. Because if you imagine in the 1970s 2 identical 10 chaining walks next to each other, one with the partitions, one without, the difference in value would be relative to the cost of the removal of the partitions.
Can I just test how far that goes? Yeah. I can't quite work out a realistic scenario, but see if we can get to something vaguely realistic. Suppose back in the 1970s, Mr. Scarfe had decided to have a work of interior decoration that happened to be done by a 1970s version of Banksy.
I thought of exactly the same.
So at the time, it's an unfashionable architect, unfashionable artist.
Well recognised as one of the greatest artists, and so
exactly.
To commission the same murals today would cost you millions of pounds.
Yes.
That is the. I was trying to think of the as it were, the highest the case could be put against me, and I think that is it. But I think you still come back to the fact that the amount by which the value of the house would have been increased by that mural would still be referable to the cost of commissioning that mural. It's just that it would cost you a lot more to commission it, because Banksy was charging a tenner in the 1970s, and come 2018, he's charging £100,000 or whatever. The value differential would still be relative to the cost. It's just that the cost would have gone up massively.
Yes, well, I mean, well, there is a limit, I suppose, to the extent of anecdotal exploration on these points.
Yes.
But we all know that property values in West London have, and other parts of London, but certainly in West London or this part of West London, have immensely risen in those 50 years. And if one wants to get into the language of proportion, I mean, out of what some would say grossly out of proportion to increases in other areas of the country. Those who bought properties in the 70s and 80s in, as it were, the right location find themselves now sitting on very high values. That's, if you like, just a common sense context of this discussion. Is it relevant to the discussion or not?
No, because when we get to 2019, I mean, the value of this, if you value it as a development opportunity, it's gone up. If you value it as a house, it's gone up when compared to the 1970s, because flats have gone up in value, houses have gone up in value. On both sides of the coin, this thing has gone up in value since the 1970s.
Yes, but what has happened, as is said in the papers here, is that in this part of West London, single dwelling house values are very considerably greater than a house in multiple occupation.
That is
generally speaking. Not
these
necessarily
things,
universally so.
No. And these things tended to go in waves. At the beginning of the 20th century, large houses in Chelsea were not desired. That's why so many of them were divided up into flats.
Yes.
But then tide changed again sometime after about the 1970s, I would guess, and houses relative to flats became more valuable.
It could be said that Mr. Scarfe undertook with great prescience the works that he did.
Yes.
Whether that's right or not, it doesn't matter in a sense, but the result is pretty clear. Whatever the outcome of this appeal, the result is pretty clear that there was a great increase in value.
Yes. But my point, just to come back to my point number 3, it's that when you get to the change in planning policy in 2014, nothing changed about the house. Nothing changed about 10 Cheney Walk. It didn't have partitions in it before, it didn't have partitions in it afterwards. The planning policy, before the change in planning policy, this building could be used as a house, and after it, it could be used as a house. So the change in planning policy didn't affect Mr. Scarfe or Cadogan. What it did do was to depress the value of a non-existent notional building that was still in use as flats on that date. And it is that depressing effect on this non-existent fictional house on that date that is what generates the discount on Mr. Jordan's case. And so I say it's not that the expenditure generates the discount. What's generating the discount is the change in planning policy. And obviously I say it is outside the statutory purpose to deliver Ms Alberti a discount based on a change in planning policy that she did not bring about and that she didn't pay anything for.
Yeah. Well, the change in planning policy is really the centrepiece of your case. The drama at the moment lacks Hamlet in the sense that we don't have policies themselves, and we've asked for those, but so that we actually see what they articulate. But it's common ground that the change in policy, common ground as a matter of fact, the change in policy had particular consequences here, as no doubt in a number of other properties.
Sure.
On the Cadogan estate, I imagine. I don't know that.
But I think that the point I'm trying to articulate is that we've seen from Chelsea that it's about not making the policy of the statutory assumption, not planning policy. The policy of the statutory assumption is to ensure the tenant doesn't have to pay twice, to pay once for doing the improvements and again in an elevated purchase price. And my point is that it's not, the tenant's not being asked to pay twice. That what's generating this discount is not the tenant's expenditure on the improvements, but the change in planning policy. My fourth point,
Yes.
a very brief one, and actually it's one I'll develop a little bit more by reference to the reality principle, it's simply that Cadogan is being hugely undercompensated, if Mr. Jordan is right, for what is being taken away from it.
The
Well, is
other
this
side of the windfall.
Yes, the corollary. I was going to say the corollary of the windfall.
And my fifth point, it's a very short point, is that Mr. Jordan's approach would be capricious, because it would mean that the price for the freehold would vary massively depending on when precisely you serve your notice of claim. At the beginning of 2014, you pay as much as 11 million. At the end of 2014, you pay potentially as little as 2.5. And my sixth point, which really just, actually, I'm afraid I said they were overlapping, I think they're perhaps all identical. My sixth point, which I have written down, is simply that neither Mr. Scarfe nor Ms Alberti paid anything at all for the right to use the property as a house under planning control. They did pay for the physical works, but the right to use the building as a house is just something that was afforded to them by the planning policies of the day. We say collectively, when you look at all that, be they different points or just the same point, but where it takes you is that to deploy the statutory fiction the way Mr. Jordan does leads you to a result which is outside the purposes of the policy for which the statutory fiction exists. I will move on now to the reality principle. It's a close cousin of the principle of equivalence, my lords will no doubt be very familiar with.
Yeah.
Can I just suggest briefly why it is that they're close cousins? Lord Newberger says in Spiros that they amount to much the same thing. And what I suggest he meant by that is that they're both aimed at ensuring that somebody whose property is taken away from them compulsorily gets fair compensation. And the reality principle tries to do that by reference to the process. By saying, well, you get full fair compensation if we adhere to reality as much as possible. The principle of equivalence focuses on the outcome. Let's look at the outcome. Is that the fair financial equivalent of what you're losing? For the reality principle, I'd like to start with Harbinger, which is at tab 17. If one goes to paragraphs 22 and 23, you will find the explanation of the reality principle by Lord Justice Lewison, which I set out, I think, fairly fully in my skeleton.
Yes.
So it's pages 246 to 247.
Thank you.
I won't reread it, but if you'd like a moment to...
You'd like us just to remind
Yes.
ourselves by reading
The paragraphs 22 and 23, please.
Right, sure. Thank you.
And 24 then, we see this. On behalf of the valuer, Mr. Howard submitted that the reality principle had no part to play in the interpretation of the hypothesis. It was a statutory hypothesis, in that case to do with the price payable to shareholders for the nationalisation of Northern Rock. Is the hypothesis, according to Mr. Howard, should be interpreted by reference to the legislative purpose. The reality principle only had relevance when the hypothesis, correctly interpreted, came to be applied. Mr. Howard cited no authority in support of this proposition. I accept, of course, that the hypothesis must be interpreted in light of the legislative purpose, but I do not accept that the reality principle has no part to play in interpretation. That would be inconsistent with the observations collected in 23.1 above. So, what Justice Lewison says, well, the reality principle can help you to interpret a statutory counterfactual hypothesis. Mr. Jordan rightly points out that Lord Justice Lewison's judgment here is a dissenting one. And he relies on the judgment of the majority and goes forward to paragraph 122, page 270. If I could just ask you to read 122.
Yeah.
That could be read as saying that the reality principle can't be used to help you interpret a statutory hypothesis. It simply tells you what you find outside the statutory hypothesis. But in my submission, that's not actually a correct reading of what Lord Justice Mummery was saying. Partly because if he was saying that, then the reality principle is, well, it's nothing. It must exist to help you interpret a statutory hypothesis, otherwise it doesn't perform any function at all. What I suggest Lord Justice Mummery was actually saying was just that on the facts of that case, that particular statutory hypothesis was one that was clear, and the statutory and the principle of reality wasn't going to help you on the facts of that case. And I say that in particular because if I just move forward to the next case, which is Monday, tab 23.
Are we coming back to Harbinger?
No, sorry, you can
No,
put that away.
fine. We'll put that away. Yes.
This is a leasehold enfranchisement case, and Lord Justice Lewison found himself happily in the majority this time.
There was dissent here as well. Is that right?
We've had all three then. We've had one we dissented and one in the Supremes. It's overturned, yeah.
If one goes to paragraphs 33.
No, there was no dissent here. This was, they all agreed.
Yes, they were.
Sorry, that was my mistake. Yes, 32.
This is Lord Justice Lewison judgment of the majority.
Yeah.
In paragraphs 32 and 33, he summarises what he said in Harbinger. And then in paragraph 34, he holds that the principle of reality is also relevant when interpreting a hypothesis required to be made.
So this is a summary of his summary in Harbinger, is it?
Yes, it is.
Yeah.
You can put away Monday.
Yeah.
And then can we go now to tab 26, a case with which my lord will be very familiar, Secretary of State for Transport and Curzon Park.
Yeah. What's happened to that case, actually? Do you know? Has it gone to the Supreme Court? I don't know.
I actually don't know, I'm afraid.
No.
I hadn't noticed it was quite as recent a decision as it is. So
It was.
yes, heard in
It
April,
was last
May
year,
last
wasn't
year.
it? It was less than a year ago. It somehow seems so much longer ago. I don't know why, but it was less than a year ago. Yes.
And again, we have Lord Justice Lewison. And if one starts at paragraph 27,
Yeah.
he starts here with the principle of equivalence and then moves on to the reality principle. 27.1, he articulates the underlying principle, which is that fair compensation should be given to the owner claimant whose land has been compulsorily taken. The aim of compensation is to provide a fair financial equivalent for the land taken. The owner is entitled to be compensated fairly and fully for his loss, but the owner is not entitled to receive more than fair compensation. And then in paragraph 29, quotes from the decision of the Privy Council in Director of Buildings and Lands and Shunfeng Ironworks. The purpose of these provisions in Hong Kong and England is to provide fair compensation for a claimant whose land has been compulsorily taken from him. This is sometimes described as the principle of equivalence. No allowance is to be made because the resumption or acquisition was compulsorily, and land is to be valued at the price it might be expected to realise if sold by a willing seller or an unwilling seller. Subject to these qualifications, the claimant is entitled to be compensated fairly and fully for his loss. Conversely, and built into the concept of fair compensation is the corollary that a claimant is not entitled to receive more than fair compensation. A person is entitled to compensation for losses fairly attributable to the taking of his land, but not to any greater amount. Ultimately, by this touchstone with its two facets, that all claims for compensation succeed or fail. Could I then just ask you to read to yourself paragraphs 33 to 38?
Yeah. Thank you.
Actually, I should say 39 as well. Mr. Jordan wrote down for me as well. And then once you've read that, if I could just ask you to read my Lord's Keith Lindblom's judgment at paragraph 82, internal page 1583. And obviously I have no quarrel with what is said there. The reality principle, the principle of equivalence, they can't override what a statute tells you to do, and they can't generate assumptions for which the statute doesn't provide. But what they can do is guide you on the interpretation of a provision that can be interpreted fairly in more than one way. And for the reasons I explained earlier, this statutory counterfactual deeming assumption is one that can be interpreted in either way, because it doesn't tell you precisely what the ingredients are of the unimproved house.
So you accept that it can be interpreted in two ways?
Yes. Yes, for the reasons I said earlier when I, as it were, retreated from what I said in my statement.
I was going to say exactly what you've just said. This sits with your withdrawal of paragraph 20, subparagraph proposition 1, earlier on. Yeah.
And in fact, I take it to be common ground, although not I tread tentatively in case I'm contradicted. I take it to be common ground with Mr. Jordan that this provision is capable of bearing the meaning that I put on it. I think that is his case. He says my interpretation is too narrow, but I don't understand him to be saying you can't get my interpretation out of the statute. He just says it's not the right interpretation to get out of the statute. So that's all I want to say about the reality principle.
Thank you very much.
I now want to turn to the two analogous cases I mentioned, Railstore and Playdale and the Tide. So you can put away Curzon.
Right. So we're going to rail.
We're going to Railstore, which is at tab 24.
Okay. Thank you.
Railstore is a rent review case. I'm sure I don't need to tell you that commercial leases of any length tend almost invariably to contain rent review clauses, and rent review clauses typically work by reference to a hypothetical transaction that acts as a proxy for the transaction going on in the real world, just like Section 9(1)(a) of the 1967 Act. And under a rent review clause, what is typically happening is that the tenant is occupying property that is let to him by the landlord for a period of time in return for a rent. And the rent is periodically updated by reference to a hypothetical transaction involving a letting of the premises on the valuation date. You assume a hypothetical letting and ask, well, how much would the property fetch in rental terms on that date? And it is commonplace for these rental hypotheses to require you to disregard the effect on rent of improvements carried out by the tenant at its own expense. And that is because it is the normal commercial expectation that a tenant will not have to pay additional rent for improvements that it has paid for. And we won't go there, but that normal commercial expectation is identified in the Sheerness case at tab 30 by the letter K. Now, what happened in Railstore and Playdale was that the lease, when it was granted, was of undeveloped land. And the actual tenant obtained planning consent for and put up two buildings. They're referred to in the judgment as buildings G and H. And when it came to the rent review, the arbitrator was required to disregard the effect on rent of those improvements. So he was required to assume that the buildings hadn't been built, because the buildings were the improvements. And the evidence to the arbitrator was that on the valuation date, you wouldn't now get planning consent to put up the buildings that the tenant had in fact put up. And the question then was, well, what do you do? Do you identify a rental value on the basis that the incoming hypothetical tenant could put up the buildings that the actual tenant had put up? Or do you value on the assumption that no, he's now caught by the new planning policy, and so he can't put up the buildings that the actual tenants put up, with the result that the rental value is severely depressed? And the answer given by Mr. Justice Knox was that you assume that the incoming hypothetical tenant can put up the buildings that the actual tenant put up, notwithstanding the change in planning policy. And the two important paragraphs of the judgment are at internal page 155, at the bottom of the first column, beginning in my judgment, and at the top of the second column, beginning I am fortified. If you don't mind, I'd just like to read those out.
Yes, well, that's just sorry. I just need to catch up with you.
Sorry.
So sorry.
Yes, where are we?
So what page 155 at the top?
Yeah.
And if you go down to the last paragraph in the first column, beginning in my judgment.
Yeah.
Okay, thank you.
And you follow through all the way
to the bottom of the following paragraph. So it's these two paragraphs. He says, in my judgment, what the Basingstoke case, the Basingstoke regime, has made clear is that there is a strong presumption against either the landlord or the tenant obtaining an advantage which is referable to a factor which has no existence as between the actual landlord and the actual tenant. Now here, there plainly is a factor which has existence as between the landlord and the tenant, in the shape of the existing planning permission on what are called buildings G and H. And unless the clause compelled one to disregard not only the existence of the buildings, but also the planning situation which their existence had led to, I have no doubt the court would not adopt such an attitude. I am fortified in that conclusion by the extremely capricious effect of the contrary view. If there were the situation which obtained here, namely that at the period when the lease was granted there was an expectation of planning permission which ripened into fact, so that a building was erected, and thereafter the planning law either went through a legislative or a policy change at some ex-hypothesi wholly uncertain date in the future, this, as it seems to me, quite fortuitous event, which might fall on either side of a rent review date, could, if the tenants are right in their argument, have the effect of radically altering the rent which it would be proper for the tenant to pay in respect of a totally undisturbed and unaffected occupation pursuant to that lawful planning permission which the tenant earlier obtained. That too seems to me to be a result that one would accept only if one were absolutely driven to it, and it does not seem to me that one is in any sense driven to it in this case. And that articulates the same concept that I've been struggling with trying to articulate, which is that the unavailability of planning consent to use 10 Cheney Walk as a house is not a factor that exists between Ms Alberti and Cadogan. The change in planning policy was a fortuitous event. It happened decades after the works were done. It didn't happen because of anything that either Cadogan or Ms Alberti did. And it hasn't disturbed or affected Ms Alberti's or Cadogan's ability to use the building as a house. And therefore, to use Ms Justice Knox's phrase, it shouldn't therefore be allowed to radically alter the price she has to pay for the freehold. Now,
just by way of footnote,
yes.
If you had gone and got planning permission for a change from flats to a house, that could be taken into account.
Yes.
Yeah.
Which of course, Cadogan could have done.
Yes. And indeed, it's one of the problems with Mr. Jordan's approach involves saying if these works weren't done in the 1970s, the building would have continued to be used as a house, sorry, as flats, for many decades. And one of the problems with that is it's very difficult to identify what would actually have happened. Because if you think about it, if Cadogan had got wind in 2013, as it probably had, that this change in planning policy was coming, it might well have done something about it. It might have applied for planning permission.
Well, it might have objected to the policy in the first place. Did it?
I don't know. I'm sure I could find out. I don't know. But any number of things might have happened. I mean, one of the things that might have happened is that Cadogan might have entered into negotiations with Mr. Scarfe to surrender the lease so that they could themselves turn it into a house before they were caught by this change in planning policy. And on this hypothesis, the building is 5 flats. Maybe Mr. Scarfe isn't living there. Maybe he's renting them all out. He might be perfectly interested in cutting a deal with Cadogan to surrender the lease so that we can capture the potential of the house before the policy changes. We just don't know.
Well, that would have been a deal done, given a number of imponderables that we can't now delve into, including the stage the policy had reached in its gestation towards adoption, and other market factors, no doubt, playing on it.
Of course, I'm not saying we can know. That's my point is that we can't know.
We can't speculate about that.
We can't speculate, but in a sense, it's Mr. Jordan's case that we know and have to assume that the building stays as flats all the way up to 2014. That's his case.
Just to understand it a bit more, I mean, if in 1972 you had chosen to put in an application for consent to change into a house,
yes,
that would have been quite possible, I assume. Did there come a point where it became impossible for you to make such an application because it was already being used as a house?
Oh, well, I suspect, well, I will defer to the planner in the court.
Well, the answer is you
quite
can
sure.
always make an application for planning permission even if you've got an established use, because it does, as it were, formalise the position in a way that, as it were, merely having an established use, although it's immune from enforcement, doesn't do. You can always make that application. Cadogan could have done it. Mr. Scarfe himself could have done it. In a sense, one is use the expression trading backwards because it didn't happen because it didn't have to happen. I'm sorry, I'm
Exactly,
coming across
that's-
my lord.
yes.
I'm conscious.
No,
I mean,
no,
the factual point is it didn't have to happen. In the sense that nobody thought to make an application because the building was being used as a house.
I mean, if
If
you're
it
going
had
to
been
if
in
you,
use as flats,
to be clear, sorry, I want to. There's a tailpiece really to what I was saying. I think that is that if you were going to sell the house, you might, I don't know, you might have been well advised to get your planning permission, even though you've got established use, so that in the marketplace, there's no, you put that to one side, as it were, as on the question
you
of
get certain.
lawful use, because that then is not contentious as between the purchaser and the vendor. I'm sorry, I am cutting.
No,
No, between you, you've provided the answer. Thank you very much.
Now, on rail store, just before we leave it, Mr. Jordan says two things. He says, one, well, rent review's different to Section 9. And certainly, it is different, but it's not different in any material sense, because it's what it is. It's a valuation hypothesis aimed at identifying what somebody should pay to somebody else for the use of their land. And Section 9(1)(a) is about the use of the land permanently. The rent review clause is about the use of the land temporarily, but it's the same broad concept. And the second thing is, he says, is it was wrongly decided. He says that because he says that the submission of Mr. Reynolds, which is articulated by letter F, just above the passage we looked at, effectively he says that submission should have been accepted and not rejected. And I simply say, well, it was right to reject it for the same reasons that it was rejected there. So that is rail store. We can put that away now. The second analogous case is Fatal, and that's tab 15. And the facts of Fatal are set out in paragraph 4, but let me just outline them quickly. The house in Fatal actually was on the same street, funnily enough, as the house in Chelsea, on Hamilton Terrace, in John's Wood. And it had started life, at the start of the lease, as merely a big house, 3,834 square foot. Very extensive extensions and improvements had been done so that it ended up being an enormous 9,192 square foot, including a swimming pool complex. And those works were improvements that fell within Section 9(1)(a)(d), and so you had to value the house in its unimproved state. And if one goes to paragraph 7, you will see that there were two issues in Fatal. The first issue was whether development potential was to be left out of account. I'm just pausing there. The argument Mr. Driscoll was making, which was rejected in due course, was that you don't merely value an unimproved building, you value an unimprovable building. So that you strip out the improvements and you also assume that those improvements cannot then be carried out. Not because of a lack of planning consent, but because he says that's just the way the statutory assumption, it's what the statutory assumption dictates. And point 2 in the case was a point about valuation methodology, which we don't need to look at the moment. And as I say, his argument that you value not just an unimproved but an unimprovable house was rejected. That's rejected at paragraph 15. But the passage which I want to draw to your attention is the penultimate paragraph in Sir Martin Norse's judgment, paragraph 19, where he says, on the footing that the Lands Tribunal's decision on the first point was, as I have held, correct, Mr Driscoll raised a third point. He submitted in the alternative that the Lands Tribunal ought to have assumed not only that the improvements had never been carried out, but also that the planning permissions which enabled them to be carried out had never been obtained. Mr Driscoll said that the member had wrongly and incorrectly treated this third point as part and parcel of the first. Assuming that it is indeed a separate point, I would reject it. It being clear, see Showson, that an improvement is a physical concept. I agree with Mr Gaunt that it is the increase in value caused by the physical works which has to be subtracted. The existence or availability of planning permission is not part of those works. By way of confirmation of this view, Mr Gaunt relied on the decision of Knox in Railstore and Playdale, where it was held that a rent review clause containing a direction to disregard any effect on rent of any improvements carried out by the tenant did not require the arbitrator to disregard the existence of a planning permission for the buildings which the tenant had built and was occupying. Now, I accept that there is a difference between that case and our case. Because in Fatal, the court was talking about a planning permission, and here we are talking about a lawful existing use for planning purposes. Now, although that is a difference, I do not accept that it is a meaningful distinction. Because I say it is highly improbable that Parliament would have wanted to draw a distinction between a planning permission to use a building in a particular way, which is not disregarded, and a lawful use of the building that doesn't require planning permission, which is, on Mr Jordan's case, to be disregarded. That, I suggest, is the sort of fine distinction that has no sense to it, and that Parliament is unlikely to have intended. So that's what I want to say about Fatal. My last section, which I think I have a little bit of time for, is just to respond briefly to a number of short points.
Right. Just to remind you, at some point, and you can do this over the adjournment if you'd like to, you were going to tie your 6 points earlier to the skeleton argument. I mean, as I say, it needn't be done straight away. That was only a reminder, nothing more. Thank you. Sorry, yes. Now you're going to deal with some points arising from the other side.
The first point is that in paragraphs 17 and 18 of Mr Jordan's skeleton,
Just a moment, let me just take up his skeleton. Paragraph 17, did you say?
yes, 17 and 18, so that's internal page 5, page 78 of the bundle. He says that my case is inconsistent with the decision of the Lands Tribunal in Sharp and Cadogan. It is not inconsistent with the judgment of the Lands Tribunal in Sharp and Cadogan for a reason I can briefly explain. The Sharp decision is at tab 29. Go to page 3 internally of that decision, it's page 474 of the bundle. You see a series of numbered paragraphs under the heading Facts. And I just want to run through the relevant facts. So it was an infringement under the 1967 Act. The valuation date was the 3rd of February 1994. You see that in paragraph 2. But prior to the valuation date, the tenant had carried out improvements to the property which had added £650,000 to the value of the freehold interest. And in numbered paragraph 5, you see that the lease to which the freehold was subject was granted on the 13th of January 1978, with 51 years from the 29th of September 1977, at an initial rent of £1,500 per annum, subject to review every 10 years for a revised rent of 1.2% of the freehold value of the premises. And at the first rent review, so that's the 1987 review, the rent moved up to £10,000 per annum. And that was the rent payable on the valuation date. And there was going to be another rent review in 1997, so 3 years after the valuation date. And you had to value the freeholds So you were assuming a sale of the freehold. The freehold yields an income, which was £10,000 per annum on the valuation date, but it was going to go up on review 3 years later. And in order to value that freehold, you had to estimate what the rent was going to go up to in 3 years' time. And we see the issue set out on page 475, at line 15. It's whether the value of the tenant's improvements was to be excluded from the revised rent at the next review. So you're valuing a sale, you're assuming a sale in 1994. The sale is of an interest that yields a rent. You know there's going to be a rent review in 3 years' time. Do you estimate the rent on review by reference to the unimproved value of the house or the improved value of the house? And Mr. Driscoll's submission was at lines 40 to 45. He said, well, you should value on the basis that the rent review is going to be of an unimproved house. Over on page 476, lines 34 to 37, Mr. Radevsky's submissions on behalf of the Cadogan estate was that the rent review should be worked out by reference to the improved value of the house. And unsurprisingly, that submission was rejected on page 478, lines 29 to 34, where it was said that the effective assumption D is to exclude from the value of the property the value of the tenant's improvements. At every stage of the valuation, that value must be excluded, so that the price is thereby diminished by the value of those improvements. So all that was decided in Sharp, and there's nothing controversial about this at all, was that if you have to hypothesize away the improvements, and part of the value in the freehold is a rental value that's going to depend on, it's going to be affected by those improvements, then you have to assume it's unimproved for rental purposes. The second point I want to respond to, Mr. Jordan's skeleton, is his assertion in paragraph 22 he says that there are two sentences of the judgment in Fatal which he says are quite inconsistent with my argument. The two sentences he says are quite inconsistent are sentences in paragraph 18 of Fatal. So I'm afraid, having asked you to put it away a few minutes ago,
Right.
can I ask you to go back to Fatal?
That's 15, is it?
19.
Right.
Tab 15. I said earlier that there were 2 points in Fatal. One was the point of law as to whether you value an unimproved or an unimprovable house. The second point was a point of valuation. And I'll just explain the valuation point. There were two ways in which you could value the unimproved house. You could value it by starting with an improved house and then subtracting something for the value of the improvements. That was called a top-down approach to the valuation. And the second way you could value it was to go, as it were, straight to an unimproved house and say, well, let's visualise an unimproved house and how much would that sell for? And that was referred to by the valuers as a bottom-up approach to the valuation. And if you go, please, to paragraph 17,
Yes.
The court there recites 3 paragraphs from the Lands Tribunal's judgment. Can I just ask you quickly to read 120, 121 and 122, that passage from the Lands Tribunal's decision? So what Mr. Driscoll was submitting was that the way Section 9(1)(a)(d) was expressed was a direction that dictated the valuation approach. He's saying it required you to do a top-down valuation, and it prohibited you from doing a bottom-up valuation. And when you then get to the two sentences of paragraph 18 on which Mr. Jordan relies, the court says Mr. Driscoll has submitted that the approach of the Lands Tribunal in valuing the property as if it had never been improved at all was erroneous. I reject that submission. What is being rejected is the submission that Section 9(1)(a)(d) dictates a top-down approach to the valuation and prohibits a bottom-up approach to the valuation. Those two sentences are being taken completely out of context by Mr. Jordan when he says that they are inconsistent with my case. The third point I want to pick up is in paragraphs 36 to 43 of Mr. Jordan's skeleton. He says, well, if Cadogan is right, then it would be impossible to value the freehold by reference to sales of similar but unimproved houses. What he says is, if you are trying to get at the value of 10 Cheney Walk in its unimproved state, then the best evidence, he says, would be a comparable sale of a similar building next door, which was still divided into 5 flats. And he says, well, if Cadogan is right, then you can't use that comparable. And therefore, he says, Cadogan must be wrong.
And indeed, the Tribunal accepted that proposition, didn't it? Explicitly. Yeah.
But it's an argument that assumes exactly the point it sets out to prove. Because, just to quote briefly from a judgment that I'm afraid isn't in the bundle, but it's not a contentious proposition. Valuation proceeds by analogy. A valuer looks for an analogue that is as close as possible to that which he has to value, and which has been the subject matter of a real transaction. He then works on the premise that if the subject matter of his valuation were to be the subject of a similar transaction, it would command the same value as the analogue. In the case of a property valuation, the analogues are usually called comparables. Yeah. So if you want to value using comparables, what you need to do is to find a good analogue for the subject transaction that you're trying to value.
Yes, I mean, your proposition here is that you can't just look at the house next door, you've got to look at the house next door with the same history as this house. Is that the point?
Well, yes, although, I mean, maybe a better way of putting the point I was going to make, which is that the question whether a sale of a building next door is a good comparable or a bad comparable depends on the answer to the question that you have to decide on this appeal.
Yes, but I think Mr. Jordan is simply saying that, isn't he, that if you want to value if you want to get at, as it were, the intrinsic value of such a property, you can't do better than looking at the house next door in it, and he adds, in its unimproved.
Yes, but I say, well, if I'm
unimproved, incidentally, in inverted commas.
Exactly.
Yes.
The question you have to decide is, this unimproved house, can you use it as a house or only as 5 flats? Because if you can use it as a house, then the building next door that is unimproved is a very bad analogue for the subject transaction that you're trying to value. Because the building next door is a building you can't use as a house, and we're trying to work out the value of a building you can.
So you say that example doesn't, or that proposition doesn't get behind your argument?
No, it pulls itself up by its own bootstraps. Next, in paragraph 71 to 75 of his skeleton, Mr. Jordan, in support of his submission that Railstore and Playdale was wrongly decided.
Sorry, the paragraph numbers again, I do apologise.
71 to 75.
Thank you very much.
He says that in support of the argument that Railstore and Playdale was wrongly decided, he says the correct approach to a rent review disregard of improvements is seen in the New Zealand case of S&M Property Holdings and Waterloo. And we have that at tab 25. concerned land which was let on a perpetually renewable lease. You could renew the lease every 21 years, and every 21 years the rent for the following 21-year period had to be ascertained. And when the lease was granted, the land was a bare and undeveloped site in 1937. And the tenant built a hotel on the site. You see that from paragraph, I won't take you there, but I'll just give you the references. You see from paragraph 37 that in 1937 the tenant built a hotel on the site. And you'll see from paragraph 43 that by 1995 the north and east facades of the hotel had a heritage listing. And that meant that if you were to redevelop the hotel, you would have to retain the facades. And in 1998 there was a renewal, and what the tenant wanted to say was that the heritage listing of the hotel operated to depress the rent because it impeded the ability of someone coming to the site to redevelop it. And the valuation formula is at page 191 at the bottom. At the bottom of page 191, the critical clause in R, and then it sets out two provisions. Clause 11, which is within 6 calendar months previous to the expiry of the lease hereby granted, the valuation shall be made of the fair annual rent of the land hereby demised, so that the rent so valued shall be uniform throughout the whole term of the renewed lease. And then 12, in making the said valuation, no account shall be taken of the value of any buildings or improvements then on the said land, but the full ground rental that ought to be payable during the new term shall be fairly valued. And all that S&M decided is that if you are directed in the valuation to take no account of the value of the buildings, then what you have to do is to assume there are no buildings there. And if you assume there are no buildings there, then you cannot at one and the same time assume that there is a building there which has a heritage listing on it. If you go to page 193, and go down to line 42, Mr. Hodder was counsel for the tenant, and you'll see he's recorded as having accepted that if clause 12 required the valuer to disregard any buildings or improvements, or simply to assess the unimproved value of the land, the heritage listing would be irrelevant.
Sorry, I didn't keep up with you.
Sorry,
where are we?
Going too fast. Page 193.
Yes.
Down at line 42. Is that Mr. Hodder accepted
Yes.
it if? So it was accepted by the tenant that if the effect of clause 12 is that you're required to assume the buildings aren't there, then the heritage listing was irrelevant. So that was common ground. The question of the court was, does clause 12 direct you to assume the buildings aren't there? To which the answer was, yes, it does. And you see that on the next page in paragraph 22, where the court held that the only value which falls to be assessed is that of the land without buildings or improvements. So it was just a case about the construction of clause 12. Did clause 12 direct you to assume there are no buildings there? If it did, it was common ground, the heritage listing was irrelevant. So if you can put away S&M, go to our penultimate case, a case on which Mr. Jordan relies for what he says is the correct approach. It's a case called Tui's and the Valuer General. It's in tab 31.
This is the Australian hotel
This is
case.
the Australian hotel case. And the question, sorry, what question? What was happening in Tui's hotel was that, Tui's Limited, was that you were being directed under Section 6 of the Land Valuation Act 1916 to ascertain the unimproved value of some land. And I think, and I couldn't swear to it, I think that the Land Valuation Act was a compulsory purchase statute. I think that's what it was. And a hotel had been built on the land, and the hotel had a liquor licence under the Liquor Act of 1912. The if one goes to page 443, you will see set out there the two sections of the Act of Parliament that were being construed. And section 6 provided that the unimproved value of land is the capital sum which the fee simple of the land might be expected to realise if offered for sale on such reasonable terms and conditions as a bona fide seller would require, assuming that the improvements, if any, thereon or appertaining thereto, and made or required by the owner or his predecessor in title, had not been made. Judgment goes on to say it's with the latter of the two sections that the valuer has to do. Now, what he has to consider is what the land would fetch as at the date of the valuation if the improvements made had not been made. Words could scarcely be clearer to show that the improvements were to be left entirely out of view. They are to be taken not only as non-existent, but as if they never had existed. So that is a decision on the construction of a particular statutory provision, which was held to be expressed in clear words as requiring an assumption that the building did not merely not exist on the valuation date, but had never existed. And so it's a question of construction of a different statute using different language to the provision that you're being asked to construe. And my lords, my final point is in response to the last two paragraphs of Mr. Jordan's skeleton. So that's paragraphs 88 and 89, where he says the decision that I am appealing is a decision of an expert body, and therefore the court should be slow to conclude that the decision is wrong. In support of that proposition, he relies on the judgment of the House of Lords in A.H. Sudan against the Secretary of State for the Home Department, which is at tab 8. It was an appeal from the Asylum and Immigration Tribunal. And what the House of Lords was not saying in the Sudan case was that if an expert tribunal makes a decision on a point of law or a point of statutory construction arising in their field, then that judgment should be accorded greater weight than the weight you would accord to the decision of an ordinary judge. It's not what the case was saying. What had happened in the Sudan case is that the tribunal had produced a long judgment that contained what Lord Brown described. I'll show you the passage in a second. What Lord Brown described as sometimes infelicitous drafting. Because of the sometimes infelicitous drafting, it wasn't entirely clear from the text of the decision that was being appealed whether the tribunal had been asking itself the right question or the wrong question. Yeah. And what Lady Hale was saying in the passage on which Mr. Jordan relies is not that, well, they're an expert tribunal, so they must have got their interpretation of the statute correct. What he was saying is that because they're an expert tribunal, it's right to proceed on the working assumption that they've probably know the law and have probably applied it.
Paragraph 30.
It's paragraph 30 is Lady Hale's remark. There is another remark I want to take to your attention. But if you read the whole paragraph, just briefly, I hope you'll see the point I'm trying to make. See this point slightly more clearly in Lord Brown's opinion. Go to the last paragraph, paragraph 43, on page 695. what he's saying is it's not completely clear from the text of the judgment have they directed themselves correctly or incorrectly. We shouldn't too readily assume that they've directed themselves incorrectly. I don't mean by any of this that the judgment below should not be given an appropriate degree of respect. Of course it should. I'm simply saying that this case doesn't support the proposition that when a tribunal is required to decide a question of statutory construction, that greater weight is to be given to it than if this had come from a puny judge in the Chancery Division. That's all I say.
Yeah. Yes.
My lords, those are my
Thank you very much, Mr. Sims. So there is, we just have our one, well, there are two outstanding requests, just to remind you. One, which is in the direction of both parties, which is to educate us more fully about the policies and their effect, and also to reconcile your 6 propositions to the corresponding passages in the skeleton argument. Thank you. Thank you very much. Thank you. Now, Mr. Tribunal, it's 9 minutes or so to 1 o'clock. Do you want to make a start?
Entirely new.
We can come back. We come back.
Happy to come back.
Why don't we come back at 5 to 2 and make a clean start then? Might be better. That suit you? Right. Good. We'll do that then. 5 to 2.